Whew, what a day. Kevin, you're right. This isn't bad. I mean, not quite up to Vienna standards, but not bad.
Totally so.
Gentlemen, I'm glad that you are both able to stay back for deliberations after a long and tiring day, but I'm anxious to hear your thoughts on the arguments.
Well, you know, we really are facing some very dicey issues of law here, and all the authorities that have been cited to us are just persuasive, not really decisive in any way. Well, what do you think?
I'll break the issue into two parts. First one is a legal issue. Does corruption securing the contract extend to invalidating arbitration agreement? Second issue is more factual issue. Was claimants directly involved in payment of bribe in question?
I think that's a good way to proceed. You know, from my standpoint, having heard the submissions of both parties, and then especially having heard Mr. Kay, it really makes you wonder. I mean, wasn't there some involvement of some sort by the claimant in this alleged bribe? It may have not been an express approval anyway, but clearly I feel that there was some sort of involvement. Of course, we need to meet the legal tests and so on and so forth, but that's my gut feeling. What do you say?
And yet they gave some free rein to whatever it takes to secure the contract.
You're right. So I suppose one could say that there was a kind of an implied authority of some sort. I mean, that's a common sense reaction. And again, we would have to get the law right on this. But again, that's my immediate thought.
I can see where the two of you are coming from. And I can remind us that modern anti-bribery legislation requires high standards of diligence against corruption from companies which want to deal in international commerce. Now, I'm concerned by the fact that there is no evidence that the claimant had taken positive steps to instruct the middleman to act ethically and within the confines of the law. In fact, it would seem at best that the claimant turned a blind eye to the possibility of the middleman resorting to bribery if the need should arise.
Precisely. To me, Fiona Trust illustrates the approach to be taken in this particular case. It says, unless it appears that corruption touched arbitration agreement itself, it should not be invalidated to deny jurisdiction to claimants.
Well, I think I would agree, but you know, we've been presented a number of authorities which cite this principle enunciated by Judge Lagering, my problem is that I'm not really sure that any of those cases really apply the Lagering Principle to deny jurisdiction over the dispute entirely. What do you think about that?
I was thinking to myself that the decision in Casia might suggest that the issue would be one of admissibility rather than jurisdiction. In other words, it would be raised as a defense on merits, but not to block our jurisdiction to hear the case. But then our respondent hasn't treated it in that way. So we may have to, or may want to, apply the Fiona Trust test and rule that we do have jurisdiction.
Yes, I think I would tend to agree. I've been looking at that as well, and it seems to me in our particular situation here that we probably really don't have enough evidence from the respondent to be able to come to a really definitive conclusion about whether there were specific instructions given to the middleman to do so on and so forth, so as to allow us to make a conclusion about bribery as such. So given that, I think, to my mind, the proper course would probably be to find that we do have jurisdiction here.
I agree.
Bearing in mind that this is an allegation of fraud, and whatever the applicable law, I think we will need to apply a higher standard of proof than in the normal civil commercial case. And so bearing that in mind, I don't think we can safely arrive at a finding of actual fraud. quite apart from the Fiona Trust principle in any event. Are you with me on that?
I think we're all together, yes.
Good. Then I think we've reached a consensus, and I'm glad that we've identified the key factors that have enabled us to arrive at this decision, in principle at least. I will now proceed to prepare a draft of our decision and send it to you. I'm afraid I'll have to trouble you by email and phone to get your inputs on the matter.
Trouble away.
No problem.
Let me know if you have any other thoughts or comments in terms of the issues to be dealt with. We should aim to finalize this decision within, say, the next fortnight. Now, let me remind you of one thing. The Court of Appeal in Singapore has held that rulings on jurisdiction are not classified as awards, but simply as decisions of the tribunal. Now, compare that to the practice of the ICC Court, which will treat all rulings on jurisdiction as partial awards. But since in Singapore, this is not to be considered an award, then strictly speaking, we don't have to send this decision in draft to the SIAC for scrutiny. But notwithstanding that, I think we should avail ourselves of the services of the SIAC, because I think the scrutiny service that they perform is a valuable assistance to the tribunal.
I certainly agree with that. Don't have any objection.
I'm sure they will be happy to assist you.
Well, thank you both once again for all of your assistance and diligence, and I wish both of you a safe flight back.
Thank you, Michael. Very grateful. And gentlemen, if I may, one last coffee.
Ganpei.
Cheers.